Thanks, everyone. It's an absolute privilege to chair this panel on law reform around the world. We're absolutely delighted that we have so many international guests here. Thank you so much for making the trip. We'll have the chance to hear from these international guests and others who are in the room on this panel, and also on a panel being chaired by Tony North from the Victorian Law Reform Commission tomorrow. I'll come to introducing our esteemed panel in a moment, but firstly, let me just give you a really quick session overview, and I also promise to be ruthless with my time as well so that we make it to our third panel session this afternoon. Law reformers across the world face very similar challenges and opportunities in their jurisdictions, but also have highly varying contexts and environments. Legal and political histories and legacies of colonisation, social and cultural norms, language, regions and technologies all inform and influence the practice of law reform, requiring adaptability and responsiveness from practitioners. Today, law reform agencies around the world will discuss how their experiences and work of law reform align, diverge, and they'll give us insight into how the discipline of law reform is practiced in a range of national and global contexts. So I'll just come to introducing our panel, and then I'll ask each of them to do a quick opening. So just to my left, Byron Leung is from the Hong Kong Law Reform Commission. Byron is the Deputy Secretary to the Law Reform Commission of Hong Kong. He's also worked in a number of other offices of the Department of Justice before joining the public sector. He was in private practice as a solicitor. Next to Byron, we have Linda McIver from the New Zealand Law Commission. Linda is General Counsel at the Commission. She previously spent 4 years at the Commission leading reviews on search and surveillance law, burial and cremation legislation, media reporting of suicide, incorporated societies, and the creation of a new offence of strangulation. Matthew Jolley is our third panellist from the UK Law Commission. Matthew previously was a managing associate specialising in trusts, charities and private client law. He joined the Law Commission of England and Wales in 2003 as head of the Property, Family and Trusts team. Since 2019, he has acted as head of legal at the Commission. He leads the Commission's international engagement, and he also sits as a judge in the Mental Health Tribunal. And our fourth panellist, Yohan Liyanage, is from the Seychelles Law Commission. Yohan was previously a judge of the High Court of Fiji, and prior to that a magistrate and chairperson of the Arbitration Court of Fiji. So please join me in welcoming all four panellists. Before I ask you all questions, I was hoping you could all spend 1 to 2 minutes speaking about your organisations, how they receive inquiries from government, how they go about the law reform process, and if there is time, just a snapshot of the inquiries you currently have afoot. Byron, if you want to go first. Thank you.
Yeah. Ladies and gentlemen, the Law Reform Commission is a non-statutory body, unlike many other law reform agencies around the world. It is not established by a statute, and it is established back in 1980 by the decisions of the Executive Council in Hong Kong, which is the highest advisory body to the government, chaired by then the governor and now Chief Executive of Hong Kong. The Hong Kong LLC is chaired by the Secretary of Justice, and there are two other ex-officio members who are the Chief Justice and the Lord Government. And all other members are non-ex-officio members, and all of them are part-time members of the LLC. Most of them are lawyers, but they are also non-lawyers, which represent different sectors of Hong Kong, so that the LLC will have the perspective not just those from the lawyers, but also from non-lawyers. The topics referred to the LLC are usually referred by the Secretary of Justice, which is the chairman of the LLC, and or by the Chief Justice. But in practice, they both usually refer topic to the LLC together. And Hong Kong LLC has a unique way of law reform process, which is under LLC, there are subcommittees which are established to study specific topics referred to the LLC. And they are usually experts in their particular areas. And just like the LLC itself, they consist of both lawyers and non-lawyers. And that's all. Okay.
Thank you. Thanks, Byron. Linda.
Thank you for giving. The Law Commission of New Zealand is a creature of statute. We are turning 40 next year, so we're looking to you for examples on how to celebrate. We have, under the statute, we need to have 3 to 6 commissioners at any one time. They're appointed by, under the recommendation of the Minister of Justice, but by the Governor-General. We currently have 3, although we actually have 2 because our President terms just come to end based on the announcement of the new president, bated breath. We get inquiries. We have usually 3 or 4 going at any one time. There is a dual track process for that. All our recommendations, all our projects have to be approved by the Minister for Justice. We can self-initiate, but we don't tend to because it's not a great use of our resources to take on a project that doesn't have a government want to implement it. We have a statutory duty to write to the Minister once a year with suggestions for a law reform program, and that's largely my role, or one of the large parts of my role, is to develop new proposals for lawful. It's great fun. So we have an informal process of consultation with key stakeholders and with public service people, and we have a website. Any member of the public can suggest a project, and so we keep a track of those and we prioritise them, do a little bit of research on them, propose them to the Minister. The Minister has a separate track where the Minister asks the ministerial colleagues for suggestions. We're reviewing this process at the moment. It's not working all that well because the projects that get selected in recent history tended to be the Minister's priorities, which then comes with its own set of problems in that when the government's changed, the new government doesn't have, a desire to implement. So we have an implementation problem, which is not unique, but it's interesting to know whether ours is worse than yours. So if anyone wants to chat to me about that, it's a subject I'm interested in. Our current projects on the go are adult decision-making capacity, duties and liabilities of company directors, hate crime, which has come out of the Royal Commission of Inquiry into the attacks on the mosque in Christchurch, recommended that we have a new offence of hate crime law in the UK, and so we are looking at whether or not that should be done. And we've just got a new reference, we haven't started yet, on the Act that governs the procedure for determining fitness to stand trial. And if you are fit, then whether or not you're criminally responsible or insane, and then which path you should go down if you need to be detained. That's good enough for me.
Thanks, Linda.
Thanks very much. Law Commission of England and Wales was established in 1965 under an act that also established the Scottish Law Commission, which is our sister organisation. The act requires there to be 4 commissioners. They're full-time commissioners, and we have a chair who's a member of the senior judiciary. We've got a total of about 70 staff with around 20 bid-plus lawyers and similar number of researchers. They're divided into 4 teams, one dealing with criminal law, one with property, family and trusts, one with public law and one with commercial and common law. We've got various statutory duties, and that includes submitting a programme to the Lord Chancellor, setting out the law reform we'd like to carry out, and that's for the Lord Chancellor's approval, and then providing advice for government as a result of ministerial references. And those are the 2 main ways that we take on our work. We can self-initiate, but we tend not to do that for similar reasons to New Zealand, though we have just put out a paper on a discussion paper which came in that way. in all of those projects, however they're taken on, it doesn't really make much difference. The impetus for taking on the project could come from us, or it could come from government. It could be for the Ministry of Justice, it could be for another department, and it could be part of a programme or an individual reference. It really doesn't make a huge amount of difference. Most projects that we do, according to our protocol with government, will be agreed at the outset. And to bring that to life, we just had a reference from the Ministry of Justice and look at the law of homicide. And then on the programme side, we've just published our 14th programme of law reform. And I'll read out the list. That will be, and this is our upcoming programme, law of deeds, product liability, consent in the criminal law, the defence of insanity, offences against dead bodies, agricultural tenancies, commercial leasehold, the management of housing estates, ownerless land, and public sector automated decision making. But before we get on to that, we've got to continue to complete the projects that we're running at the moment, which is another list, I'm afraid. That's cooperatives and community benefit societies, digital assets and electronic trade documents and private international law, friendly societies, objects in museum collections, contempt of court, criminal appeals, burial and cremation, business tenancies, chancel repair liability, kinship care, agricultural law in Wales, aviation autonomy, new funerary methods, and compulsory purchase. Anna, thank you. And you try doing. Alongside that, a couple of things I'll say really quickly, because I know we're short of time. In most cases, those projects, when we publish our report, we will publish a bill with them, something that McIver was talking about earlier, which we find very helpful for the reasons that he gave. We'll also publish impact assessments where we're setting out to government what we consider the likely cost and benefits of implementing reform would be. And alongside that, as a final comment, we do provide implementation support to government in various different ways that can involve us just answering questions from government and supporting our recommendations, or seconding members of staff over to government for them to work independently with government on that work. Thank you.
Thanks, Matt. And Matt has been at pains over the last few days to remind me that quantity of work isn't necessarily a good thing for a law reform commission under pressure.
Good afternoon.
Thanks, Yohan.
Yes, good afternoon. I'm representing Seychelles Law Commission. We just started walking because we are just 2 years old. So when you are sitting next to an elderly or two elderly commissions, you feel protected. Yes. So thank you for the opportunity. And Seychelles Law Commission was established in 2022. The law came into operation in 2022, but it came into operation in 23. So it's a very new organization. We have 7 commissioners, 6 of them are part-time commissioners, including the Chief Justice and the President of the Court of Appeal, and also a member from the National Assembly, and also 2 legal practitioners representing the legal practice, and also the Attorney General. So we have 3 main objectives. One is law reform, the other one is to review the law, and also we have law reporting as well. And not only that, we have to revise the law as well. So it's quite a handful. However, we have a small staff right now because we just established. And our reform work currently, we can take proposals from the National Assembly, from the judiciary, and also from the general public as well for their ideas and comments. Right now, we are working on how to reduce backlog in the judiciary by reforming the law, the current law, and also to see how best we can have the criminal procedure more effective with the current trends. So that's where we are right now, Seychelles. For those who are not very familiar with Seychelles, Seychelles is a small dot in the in the Indian Ocean, next to Kenya. You will find it. You have to zoom a little while to find it. Yes, so I had to give this brief to the taxi driver who took me from the airport yesterday. And then I have to also spell Seychelles, because it's not Seychelles, it's Seych. So that's where we are. Thank you.
Thanks, Yohan. My next question, Linda, I was hoping you could start off by answering this question, and then I'm keen to hear from the remainder of the panel. How does your organisation engage with the public, and in particular, do you have any specific methodologies for engaging with hard-to-reach and marginalised communities?
Yes, it's something we put a lot of emphasis on, and I had 4 years at the Law Commission from 2012 to 2016, and we've come a long way since I've come back. I'm very impressed with new ways of consulting. Every project usually has a expert advisory group, but that's fairly standard. One of the new things we do on some projects is a lived experience group. So this is Jeff Schick, he's our commissioner, and on his project to do with adult decision-making capacity, they've had a lived experience group as well as an expert advisory group, which they found hugely valuable for that particular topic. Another thing we've found ourselves doing is, so every project has a consultation strategy. You look at who your target audience is and what your subject matter is, and you make a strategy. But one of the things that's come out of, we've noticed recently, is the need for certain projects to publish documents in a variety of ways. So the adult decision-making capacity project has produced, and I wrote them down, accessible formats included New Zealand Sign Language, easy read, audio, large print, and braille. Our current project on hate crime has produced translations, because it came out of the Royal Commission's inquiry, which translated its documents. So the translations included English and Māori plus 15 other languages. It's expensive and time-consuming too. It did delay things. And we noticed that we didn't get submissions wrong representing all of those groups. So I think decision-making is going to be done again in relation to the final report. But we did find it important to try to do that, to reach out. And somebody else mentioned in the project we've just completed on discrimination for non-binary, trans, and people with innate variations of sex characteristics. Particularly that last group, innate variations of sex characteristics, is a very small group of people within New Zealand that are out and represent that. We needed to reach them, so we employed somebody who was known within that community to interview and to report to us, because that was felt like the best way of getting the best quality information in relation to that.
Thanks, Linda. That's really interesting and great food for thought, I think, for many of us in the room. Byron, anything from Hong Kong's perspective?
Hong Kong is relatively small in terms of size and population, so we engage the public mainly by consulting them on our tentative recommendations contained in our consultation papers before the Commission and the subcommittees would finalize their recommendations after considering the responses that we collected from the public. And our consultation exercise usually lasts about 3 to 4 months. That would allow sufficient time for the responses to be collected. And in case of need, we will extend the consultation period upon request. And our consultation exercise is quite extensive. We've published all our papers and reports bilingually in both Chinese and English, which are both are official languages of Hong Kong. And also, we will release our bilingual press releases, and also we will usually publish our papers and report by way of a press conference. And at the press conference, we will address the questions from the press, and so to bring the public's attention to our recommendations and explain the rationale behind. And we will also attend the relevant panel meeting of the Hong Kong legislature to explain our recommendations and the rationale. And also we will attend questions from the media, including television station, radio stations, and the press. So representatives from the LRC will also accept invitation to attend conferences and meetings to explain our recommendations included in the consultation paper, and also address their concerns and hear the views. And we will also attend briefings, appoint invitation by the stakeholders, and also to explain our recommendations and also to hear the views. And all this is to engage the public, including hopefully the harder to reach community, and also more importantly, to hear the voice, and so that they will have the voice in the law reform process.
Thanks, Byron. It sounds quite daunting, that much media coverage, but really
it can be.
Yohan, as you mentioned, the Seychelles Law Commission is relatively new. I'm wondering if you've done any particular thinking on consultation and engagement with hard-to-reach communities, and anything you can share with us today about how you go about that.
Ruth, the short answer is we haven't done any public consultations as yet. However, there is a provision to consult the public and to engage them, and also we have made it clear that anybody who is in the public can make proposals, and they can come and send us feedback or come and meet us even for one-to-one meetings. And because Seychelles is a smaller country and with a smaller population, we can do that because we can engage public even on a day-to-day basis. Sometimes, you see the same person maybe 2-3 times during the week. So there is a possibility of doing that. And when we talk about public consultations, always we need to think that why we need public consultations. Is it just ticking a box, or do they really have a voice? So if they have a voice, something that I have found that sometimes people, they do not understand what we propose. So when Justice Kirby in the morning mentioned about what we perform is the people's work or the people's mandate, it sounds that we are very much connected to the sovereignty, notion of sovereignty. So that's a two-way thing. So you have a duty to inform what is there for the public as well. What I have found that sometimes, in Seychelles, people say that, there's no law. When you find out and when you talk, when you engage with them, it's about their understanding. There is law, and it's not effective, or they're not feeling that part of the law. So public consultations in that sense, I think, should be a two-way thing rather than just hearing them. I think we have to engage with them as well for get them to understand the law. So that's my view.
Thank you, Yohan. I think two-way consultation is a really critical concept. Matt, you spoke to us yesterday about all of your publications being also bilingual, produced in Welsh as well. Anything additional in terms of the way that the UK Law Commission engages with marginalised communities?
Yeah, well, actually picking up on Johan's comment about being an older law commission, one of the things we find, I notice as you see yourselves getting older is you get a lot wiser, but you also find it increasingly difficult to get the TV to work. And we've got quite a lot of we get a lot of insights into how to consult from this type of international collaboration, and some of the things I see being done in Australia and elsewhere is really, really, awe-inspiring. just three things I'd mention really quickly. I'd say one of the things that came out of that awful time with COVID was a real jump in the ability for us to consult virtually. And sometimes it's really important, as today, to be in the room with people, but equally there can be ways in which you can construct virtual events that allow participation in a way that wouldn't be possible face-to-face for reasons of cost, travel, time, whatever. In certain projects, we've had some real success using EasyRead, which is a sort of professional approach to producing documentation in a form that can be understood by people either with learning difficulties or who've got various other challenges. So that's something that's worked well with us. And recently we've been experimenting a little bit with animation, which again, it's not something we do on every project. It can be expensive and time consuming, but where appropriate, that can really help as well.
Thanks, Matt. And if the conch could stay with you, please. You mentioned a bit earlier about impact assessments, publishing impact assessments with all of your inquiries, which you spoke to us about that yesterday, and I find really interesting. So this is a question for the whole panel, but if you could please kick us off with how do you measure success or impact of your work?
Well, I'll talk about impact assessments.
Please.
I think it's something it's a bit divisive because it can feel as though you're doing government's job and somehow not being independent. It's also not something that every lawyer gets up in the morning wanting to write an impact assessment. They think it's the work for economists, or it's not for them. We took it on about 15 years ago reluctantly because we just found that government were taking our recommendations and somebody, usually relatively junior, was looking at them. An impact assessment had to be done. They were writing them. They didn't know what the benefits of the local reforms were. Much easier to find the costs of reforms. And so what they were doing is they were mangling our recommendations, and essentially we were losing traction in trying to get implementation, which isn't everything, but something. And so we decided we'd take that on ourselves. And I think for organisations who are considering that they might do just some form of it, it doesn't have to be the full job. You might just want to be a chapter at the end of a paper populating it with your thoughts about the costs and benefits. It's not all about money. It's not something that needs to be done by economists. It's about telling the story of why you come to the conclusions that you have, why you've chosen the option that you did, rather than the options that you've rejected, why this is something that should be done. And it's the kind of stuff that I think is in the bones of law reformers as to why you've done it, why it's important, why you've spent all that time and sleepless nights coming to those recommendations, and it's telling a story in a different way to people who are used to thinking in the terms of impact assessments and costs and benefits. And we've had very many reports of reading, not reading our beautiful summaries, our beautiful reports, but they read the impact assessments.
Thank you. Anything from the other panellists on how you measure impact or success? Please jump in.
Yeah, well, just following up on that one, we don't write the impact assessments; they're done by the public officials, but we do write our reports with their need to do that down the track. So we are aware of what they need, and we're always trying to tell, make sure that the reports provide that information because we don't want to put a hurdle to implementation. In terms of measuring implementation, that is also my job. We have a scoring system that we borrowed from probably you, and it's our scores have been dropping recently. It's very frustrating because, of course, the reason for implementation is largely out of our control. We've recently taken up. We have a compulsory government response if the government is not going to implement our report within 6 months, and it has to be tabled in Parliament. One of our frustrations recently is, despite that need, the quality of the government response is dropping. So I've just done an assessment of this in recent years. They sometimes have said, "Thank you for your report. We don't even make it in principle." Yeah, sometimes they used to say we agree in principle, but we have to do some more work. Lately, there's a little bit of a trend to not even say that, and I put that down to the fact that the minister is not freeing up official time to put into they've got other priorities for the officials at this particular moment, so we have to wait to see. And that's probably enough.
Thanks, Linda. Byron or Yohan, anything on impact?
The impact assessment actually is some food for thought for us, and we haven't done that. It's a matter of practice. but it will be a possible option. But of course, there are some concerns for us. Of course, is one of them, and we don't have economists to do it, and we are not sure about the how useful it would be in convincing the government to implement our recommendations. And because in engaging impact assessments, there are usually some sort of underlying assumptions which can easily be dispelled as being artificial, and that would challenge the foundations of the impact assessments. So we are in two minds, actually.
Yes, Steve.
Well, for the impact assessment, I think my view is it should not be subject-centric, because as Justice Bromberg spoke during his speech, we are talking about a legal infrastructure. So we are investing on legal infrastructure. So it's not about a particular beam of your house or the pipe that you should be investing on. So I think post-legislative scrutiny should come in handy in place of impact assessment, because you need a holistic approach towards reforming law rather than having a subject-centric approach. Because at the end of the day, we are problem solvers, and then we have the duty of improving the society. So that's my view.
Thank you. Thanks, Yohan. Byron, I wanted to start with you on this question. This is my second last question. If you could list three of the biggest challenges that your organisation faces, what would those three be?
I think the biggest challenge of the Hong Kong ARC, I think, is quite common among the law reform agencies around the world, is about implementation. Although not a statutory body, HKLRC works separately from the government. And the downside is that the LRC doesn't have the mandate to ask the government to respond to our recommendations in any particular way. And that means the government may not accept our recommendations. And that's the hurdle one. And there's also another hurdle. Even with the government support, even if the government implements our recommendations by way of legislation, we still need to get the support from the Hong Kong legislature. Under the Hong Kong system, the head of the government, i.e. the chief executive, and the members of the Hong Kong legislature are elected separately under different mechanisms, which means any bills tabled by the government, introduced by the government, may not be accepted by the members of the legislature. So there's another hurdle. And also thirdly, with the rapid developing in terms of technology and economy, in case our recommendations have not received timely support from the government and also the legislature, the validity and the relevance of our recommendation will diminish very rapidly.
Thank you. Please.
Me? Probably top of my list is one of the key ways I'm focusing on to try and address one of the implementation problems is to get projects that are most likely to be implemented. So trying to get projects that are not high political priorities right now, that maybe more that boring infrastructure stuff that we're actually really good at, and that is not going to get the attention of government departments. So trying to pull the levers we've got, which are a little bit limited, to get good quality projects, proving our value. And I've got lots of notes, snippets from his talks this morning about just little ways in which extra ideas for how to prove our value, because it's all about the soft skills, really. Shrinking budgets is the other one that is not unique to us, apparently, but it would be nice if they got a greater sense of our value, but we're doing everything we can.
Thanks, Linda.
Shall I go? I'm going to add to funding. I mean, we're well funded and we're really lucky and we don't take that for granted. But we're doing a lot of projects and our project teams are actually really small, probably smaller than yours in many cases. And in fact, we've got a challenge not just in terms of the quantum of funding, but how the funding comes. With funding coming from departments to pay for particular projects where you have to do an enormous amount of work, not just to be seen as a service provider, as opposed to an independent law reform body conducting a statutory function. So that's number one. I think technology is both a real challenge and a threat. It's kind of an opportunity and a challenge, and taking both those sides. We've been involved in some technology work, and we're going to talk about that tomorrow. It's something that is difficult for law reform bodies to do, but it's something that I think if we embrace it can be a really important area because it's having massive impacts and will have increasing impacts on the way that the law operates in practice. And the final one I'd go for is just trying to keep the relevance of long-termism in a short-term world. You know, people are allowed 258 characters on Twitter. That's a lot less than our reports. You know, the attention span is less. The trust in experts is less and is being, you know, in my country and in other countries has been really fueled by people with agendas who don't like the idea of independence, who don't like the idea of people doing things on a principled basis because actually the real hustle is in town in terms of people wanting to do what they want to do. So, you know, that's why we are important and why we need to continue to sort of fight to do what we do. But I think, you know, we're swimming against the tide and we have to swim hard.
Well, law reform, I think the biggest challenge is how we can get law reform to become a culture. Because what we have seen, there's so many institutions. You have the executive where they can push their own reform work. And then we have independent law reform agencies such as law reform commissions. We have our own agenda. And then each ministry and department, they have their own research team. They push their own agenda towards their benefit. So I think what we need is a proper culture of law reform. For that, we need for it to become a reality, I think we need to work together rather than competing with each other. So law reform agencies or law reform commissions should not become another competition in the society. What I think we need to do is to help other agencies to coordinate and for people to understand at the end of the day what is law reform is about, and from a particular law reform, what they're going to get or the benefits that they're going to get at the end. So for in taking that path, I think, you know, we will have so many challenges such as the budget restrictions or the technology. For a small jurisdiction, we have challenges in finding the correct manpower. So these are, I think, challenges, you know, that could vary from a jurisdiction to jurisdiction. But at the end of the day, if we can work towards getting the law reform into a culture, I think we are all safe.
Yeah, just quickly chip in on funding. We are very fortunate in terms of funding, not because we are effort, it's just because we are fortunate to have lots of volunteers. All our commission members and subcommittee members and chairmen are volunteers. They have their own full-time job, but they volunteer to do the work for the Law Reform Commission, serving as members or chairmen of subcommittees. So we are fortunate on that.
Thank you. And my last question, Yohan, if you could please start by answering this. Where do you hope to see your organisation in 10 years' time?
Ruth, for Seychelles, because the law was not accessible to the public, even at the moment. So we just launched our website. But because of or the culture or the practice that was there before, people do not know their law. So one of our primary targets was to get the law to the hands of the people, for them to access, for them to read, for them to understand. That is one of the biggest challenges that we have, and we are getting there. So how I see Seychelles Law Commission in 10 years' time is for people to firstly understand what the law is, and then for them to have a broader understanding. It makes us easier for us as the Reform Commission to reform the law, because when people identify the problems, they will let us know. And when the other institutions, they realize their challenges, they'll come to us for reform needs. So you get more and more proposals from that point. So that's how I would like to see Seychelles Law Commission in 10 years' time.
Thank you. Matt, for your 70th birthday, what's your vision?
Well, assuming we survive for 10 years and humanity survives for 10 years, I think we shouldn't be looking in terms of growth particularly, or just implementation. As I said, that's really important. I think, we should be continuing to focus on doing the job that we're doing, being a respected organisation with a quality output, and possibly, a thriving independent organisation serving our robot masters.
In 10 years' time, I hope that we currently have a 1-year program, because we have to keep reporting to the Minister every year. I hope to grow from the Law Commission of England and Wales and have a 3-year program, or from Scotland and have 5 years, but probably 3 is more realistic, and which will hopefully give us that sense of it being a law reform program, getting ministers to buy into that longer term thinking. That's the main point. Yeah.
Thank you.
Our mission is to attain and maintain a reputation of excellence in law reform, and our mission is to make the law of Hong Kong more accessible, more effective, and more in tune of the needs of the Hong Kong society. I think in 10 years' time, I hope we will continue to do that.
Thank you so much. The title of this panel was Synergies and Differences Around the World, and I think we can all agree that there are far more synergies than there are differences. We've heard ideas for engaging with diverse and hard-to-reach communities. The panel spoke about impact and different ways of measuring success. The panel also spoke about the importance of long-term thinking, funding, ensuring our work remains relevant to the people we need to implement it. And the panel spoke about the need to develop enduring relationships and enduring culture of law reform. And when it comes to vision, I think it's very much a shared vision with everyone in this room here for people or for the community to identify areas in need of law reform, to not just focus on growth, but to focus on being institutions that are respected, being institutions that are thriving and independent, to develop longer-term programs of work, and ultimately for more accessible and effective laws for the communities that we all serve. So please join me in thanking this very esteemed panel.